Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. In this video, we are going to discuss the much debated for the past 2 or 3 days, much debated issue regarding the abortion rights. Honorable Supreme Court of India clearly stated that a woman has got a right to get abortion within the period of 20 weeks according to Medical Termination of Pregnancy Act. Now, you can read the case as X versus Principal Secretary, Health and Family Welfare Department, Government of National Capital Territory Region, Delhi, in Civil Appeal number 5802 by 2022, decided on 29/9/2022 by Honorable Justice Dhananjay Chandrachud, D.Y. Chandrachud, A.S. Bopanna and J.B. Parthiwala, who observed that a woman who seeks a legal abortion cannot be required to seek consent from the parents or elders of the family. This is not necessary. How this happened? What is the genesis of this problem? So I should not disclose her name, but why this topic has come, better you know, right? The petitioner, she is a lady, aged about 25 years, she is unmarried, she is from Manipur. This woman filed a writ petition before the Honorable High Court of Delhi to permit her to terminate her ongoing pregnancy. So, with a registered medical practitioner before 15/7/2022, whereby the period of gestation, this is 24 weeks, will be completed. Actually, at that time, she was carrying 22nd week of the so-called pregnancy. Right. The petitioner hails from Manipur, already I told you, and she is an Indian citizen. She is staying in Delhi. Right. She has got consensual sex, or she has got intimacy with one person, and actually she is having 4 sisters. They are a family of 5 sisters. She is the eldest of them. She has to educate them also. Of course, while doing some job in Delhi, she got pregnancy to that it is consensual, out of consensual sex only. But in the last minute, that man, so-called, he said he can't marry her. He can't marry her. So therefore, please remember, so as the partner refused to marry her in the last minute or left her at the last minute, she wanted abortion. Why? Because she could not bear the stigma and harassment of the society of a single mother or an unmarried mother. Definitely, the society will pinpoint her. There's no doubt in it. So, she cannot, moreover, she cannot raise and nurture the child also, because she is a poor lady and she has to take care of her 4 other daughters also. So therefore, she wanted the pregnancy aborted through an RMP doctor. So you know what RMP doctors definitely, normally, if they are actual influential people, they will get it done. Otherwise, they are fearing of Section 312 to 318 of the IPC, that is miscarriage. If anything happens, if any miscarriage happens, they will definitely booked under the Section 312 IPC, which I have done during my earlier career. When I was SI Tangutur, we have booked a pseudo nurse, like మన పల్లెటూరులో మంత్రసాలను అంటారు చూడండి, ఆవిడ ఉమ్మెత్త పువ్వు యొక్క కాడబెట్టి అమ్మాయి వెజైనాలో తిప్పినందువల్ల చచ్చిపోయింది. బాడీ తీసుకెళ్లి ఊరి చివర పడేశారు, అనంతవరం అనే విలేజ్లో. బుక్ డార్ 312, అందుకని ఆ సెక్షన్ మర్చిపోయాను, చిన్నప్పుడు సెక్షన్ కాబట్టి. రైట్. సో 312 to 318 of the Indian Penal Code. And secondly, the RMPs, that is registered medical practice, means doctors only, they insist on the consent from the woman's family, and they insist on the documentary proof like Aadhaar card, marriage certificate, and also if it is more than 20 weeks. So section 3 allows you up to 20 weeks. If it is more than 20 weeks, 24, more than 20 weeks, definitely even up to 24 weeks also, they have to get the judicial authorization. Suppose if the woman got pregnancy through rape, definitely she has to get the judicial authorization. And please remember, if these people are not able to produce the so-called conditions or fulfill the same conditions, they will not oblige or they will decline to conduct the termination of pregnancy. Now, since this matter has come to the notice of the Honorable Supreme Court of India, so Supreme Court of India, 3 judges bench clearly stated that the woman alone has got right over the body. Article 21, right to life and liberty, provides the right of woman to undergo abortion when her health is in stake or health is not good. So therefore, the RMPs must refrain from imposing the so-called extra legal conditions. There is no condition that she has a pregnant woman, that too a major woman, she did not obtain any consent from the family members. Husband consent not necessary. Same thing happened. That boy is still weeping. Marriage just I think last November or so. By November next year it will be 1 year. So the woman got pregnancy. She went home and she got aborted and she did not inform this boy. And ultimately she filed a case of 498A against him. Of course, this is another part. So informing the husband is also not necessary. So please remember. Now, as far as this woman is concerned, she filed a petition, writ petition, to give her permission under Section 3, Clause 2, Subclause B, Subclause B of the Medical Termination of Pregnancy Act 1971. But Supreme Court clearly held that Section 3 does not apply since the 20 weeks period has been completed and now she is 22nd week. So High Court dismissed the petition. Now the matter has got to the Supreme Court. Right. So in the meanwhile, because she is going to complete the 24 weeks of gestation period on 21/7/2022, Honorable Supreme Court of India gave the interim orders that her pregnancy may be terminated. Right? It was successfully done. Since it is successfully done by the hospital. But since the issue involves substantial questions of law, questions of fact, and so many of the public matters, therefore, the court has taken it for further discussion. So actually, now we have to interpret the matter. To interpret the matter, normally we take literal interpretation according to section. That's why High Court said no, it will not apply. But please remember, it is a beneficial construction. Medical termination pregnancy is a beneficial construction. So you have to read in that line. So even live in relationship, it is also equal to marriage. So please remember, no distinction between married and unmarried. If the woman is major, she can undergo the termination. Section 3 deals with the termination of pregnancy. Please remember, within 20 weeks. Right? And even minor nowadays, if she got pregnancy, if she wanted to get it aborted, yes, she can do it. There is no necessity from any head of the family. And now in this case, another topic has come. What is marital rape? So far, marital rape, even though it is in discussion, it has not come in any part of the judgment. But here it has come. If the husband forces the wife for sexual intercourse, as a result of which she gets pregnancy, it can be taken as marital rape. Of course, only as far as the medical termination of pregnancy. That means the pregnancy can be aborted. For that, Section 3BA of the MTM. So, marital rape. Please remember, this discussion is only for Medical Termination of Pregnancy Act. But you may be knowing, Section 375 of the IPC, Exception 2, I believe, it gives definitely exception to the marital rape if the woman is aged more than 15 years. And the important point we have to discuss is teenage pregnancy. This is another problem. So please remember, teenage pregnancy, no doubt, she has to be careful, but the doctor can terminate. And please remember, according to Section 19 of the POCSO Act, if any RMP doctor, registered minister, comes to know about the so-called issues, then he has to give information to the police. But here, he need not disclose the identity of the girl. So, minors also can go for abortion. Very liberal construction. Of course, lot of discussion is there. I don't want to go for the discussion, but I want to confine myself to the important points of the judgment. Lot of discussion has been gone. మేధావులంతా పేద మంది చెబుతున్నారు, మనకు అంతవరకు వద్దు కానీ ఇంతవరకు తెలుసుకుంటే చాలని నా ఉద్దేశం. ప్లీజ్ రీడ్ ద జడ్జ్మెంట్ carefully and enrich your legal knowledge. With this, I am concluding. Thank you.